And that's a recap of how far we've come with the banking crisis. Well, yesterday, boss of defunct UT Bank and Beige Bank were in court. One was granted bail, the other remanded into custody for a week. And that's Mr. Mike Nyeneku. Well, the President of the Republic spoke on this issue of the banking crisis and the fact that they're determined, to get people to answer for the wrongs that they may have done in this whole issue of the collapse of the banks. I want us to take a listen to the President Akufo-Addo, who served notice more persons will be brought to justice over the collapse of some banks and microfinance firms. His comment come as state security agencies begin prosecution of CEOs of defunct UT Bank, Prince Kofi Amoabeng, and Beige Bank, Mike Nyeneku, over their roles in the collapse of at least two of the banks. Mr. Amoabeng was yesterday granted bail, whilst Mr. Nyeneku was remanded in police custody after both were charged with, among others, stealing. So here's President Akufo-Addo on this issue.
We have begun bringing those responsible for the banking crisis to justice. We have one case in court, and if prima facie evidence of criminality is found in the other ongoing investigations, which according to my information is likely, then the perpetrators of the crises, i.e. both regulators and individuals, will face justice soon. We had to take painful but necessary measures to sanitize and save the banking system. In effect, 12.58 billion Ghana cedis of public funds was injected into the 9 banks and many microfinance institutions following their malfunction. It is worthy to note, however, that the jobs of some 6,500 workers were saved as a result, instead of the 10,000 that could have been lost, in addition to the protection of funds of 4.6 million depositors. We have also ensured the creation of a strong set of indigenous banks. The latest banking sector report of the Bank of Ghana reveals that as of October 2019, the banks posted a profit of 2.9 billion cedis, representing a 45% increase over that of 2018, as the reforms initiated by the central bank begin to take effect.
Mr. Roxy Nelson Daframakpo is Member of Parliament for South Dai, but he's also a private legal practitioner. He joins us again today. Good to see you again. Thank you for making time. On this issue of this arrest, there's also another legal issue of 2 pregnant lawyers. We will talk about that after this, but we want you to help us with, very basic understanding of what we're witnessing in terms of what happened in court yesterday. Also knowing that investigations have been going on for about 2 years. Suddenly, we heard of an arrest and appearance in court yesterday. What does that mean?
Thank you very much. It's my pleasure to be here again. You can understand the decision by government to strike at this time, because they've come under intense pressure regarding non-prosecution, as it were, or as it appears, non-prosecution of the actors, the whole banking clean-up saga. But what baffled me yesterday was the nature of the arraignment, because these are people who have been constantly going to the police station upon invitations to give statements and further statements. So if prosecution is of the opinion that they have gathered sufficient evidence to give them a basis to make a prima facie case, for which they have to arraign them before a court of law, we have moved away from this primitive way of prosecution. You arrest somebody in a couple of hours, you storm a court at 2 p.m. and ask for a bail, or ask for denial of bail, that perhaps you are still investigating the matter. So the court should deny bail. Normally, that's the way AG makes their submissions. But as it turned out, he was able to, his lawyers were able to persuade the court yesterday. But unfortunately, the lawyers of my friend Nineku couldn't persuade the court. So he has to stay in police custody for another week. And for me, it's worrying in the sense that on the 31st day of October,
which year? 2019,
pursuant to the Supreme Court decisions in Martin Kpebu number 1 and number 2 versus the Attorney General, the just outgone Chief Justice, Sophia Akufo, CJ, as she then was, issued a practice direction regarding the conditions under which an application for bail could be determined or could be considered by a court of law. And she moved away from the constricted conditions outlined under Section 96 of Act 30, that is Criminal Procedure Act, to indicate very numerous grounds under which a court should consider in the grant of bail. So technically now, you can't use denial of bail as a punishment to punish an accused
Is that
person.
your interpretation?
That is
because
my
the judge was not convinced about the lawyer's position.
Hold on, Mama V. I have given you a context. Nineku has always been in this republic. He was invited yesterday, and he honored the police invitation.
But isn't that for the lawyer in court? Because the judge, we assume, judge doesn't know anything about this. You have to tell him.
No, that is
and
the
you have to convince him.
The judge, and I hear it was a circuit court.
Yes.
They went before a circuit court.
Yeah.
The judge is bound by the conditions as outlined by the outgone CJ in this practice direction.
So even if the lawyer is not convincing enough,
I don't think the lawyers were not convinced, were not persuasive of the court.
Well, but that was according to our reporter who was in court. That was the reason the judge gave.
And
because this is same judge,
yes,
looking at the two gentlemen,
yes,
the two cases. In one, he grants bail, and then in the other one, he says he's not convinced by the arguments. In a
set of facts that are similar. Because we speak of persons who have been involved in the banking crisis. So what narrative of facts will be materially different from what will be narrated?
Yeah, but these are different cases.
No.
So you have a responsibility. So are you saying that you don't have a responsibility as a lawyer to make your case independent of the other person's case, even though it's the same judge, similar facts?
It appears for me to be too orchestrated. Because look, these are persons who are already under serious investigations. So when prosecution has come to the determination that we want to effect arraignment, just notify them. So for instance, this morning, we could have said that this morning at 8:30, please appear in court with your lawyers.
But that's at the discretion of the judge.
Yeah, but that is the abuse that this party's direction seeks to check.
In this particular case, yes, with what's the practice direction, yes, that you keep talking about, what should have been, what should have happened?
Very well. Now, if you look at the first condition, it says that in determining what amounts to unreasonable delay, for instance, the court shall consider, that's in the grant of bail, the court shall consider, 1, the number of witnesses that prosecution needs to call, the number of counts that the accused has been charged with, the number of essential elements of the offenses with which the accused has been charged with, which have to be proved by the prosecution. 4, whether in proving any essential element that the prosecution requires a report or document from an institution or an establishment over which the prosecution does not have control. 5, any special circumstances of the case, including but not limited to the following: deteriorating health condition of the accused or any of the witnesses in the case. 2, advanced age of the accused or any of the witnesses in the case. 3, the sensitive or public interest nature of the case. 4, the likelihood of the trial of the accused not starting any sooner. 3, the severity of punishment with which conviction will entail. Then 4, whether the accused, having been released on bail on a previous occasion, has woefully failed to comply with the conditions of the recognizance entered into by him on that occasion.
But this does not
5,
apply in this
yes.
case.
5, whether or not the accused has a fixed place of abode in the Republic or is gainfully employed.
But how would
6.
the...
Now, Mama V, hold on. 6. Whether the sureties are independent of good character and of sufficient means.
Okay, so this is on paper.
This on paper.
But how would the judge know?
This is a practice direction.
Yeah,
that
but don't you have a responsibility as a lawyer representing your clients?
I agree, but for a
to make all these things clear to the judge?
Mama V, for a judge to simply say that I am not persuaded without giving reasons. That is why when judges write, when they deliver ruling or judgments, we call them reasoning behind the decision. The judge should reason with us. Give us reasons why you felt not persuaded. You are clearly told the things, the conditions, the factors to consider in this practice direction. I am only saying that this kangaroo style of conducting trials, we have clearly moved away from it.
But there's another leg of it. They can go on and appeal the decision.
Exactly, but he's supposed to come back in a week's time. You know, the appellate process is, it will take much longer than that.
Okay.
And once you occasion that, it may torpedo the normal trial process.
Okay, but let's also say that this is not the substantive case. This is just bail. This is just exactly.
And
all right.
It's unfortunate he has to stay in police cells, and it also brings to mind the situation of COP, ACP Agoju. You know, all these factors are supposed to be considered by a court.
Yeah.
They look at it and they gloss over it, and they still do things in a way that does not conform to modern practices of conduct.
Okay, so unfortunately, we'll have to let you go and end this because you're also going on Radio Joy from on the Super Morning Show. But this practice directive, I'm interested in direction. So we will have a full-blown conversation on this in the near future.